Today I wanted to welcome you to our Tuesday Talks. My name is Jennifer Peck, and I'm one of the attorneys at the law firm of Solomon, Steiner Peck. Today I am sharing this talk from my home, so I'm hopeful that my dog and cat don't make a guest appearance on it. But for the last year and a half, my firm has been hosting these online webinars to give some general information on different topics concerning Medicaid as well as estate planning. I'm really hopeful that in the near future, we're able to again present these seminars live so that we can have an interaction with you, as I feel that that's a better way to engage. So before I begin, I just want to go over a couple of housekeeping things, so to speak. And that is that if you have any questions, you can type them into the chat box, and I will do my best to be able to talk as well as look at that chat as we go. Now, I cannot answer and give specific legal advice in this type of a format, but what I can do is give you general information and answer general questions. So next week, my partner, Michael Solomon, is also going to be giving a presentation. And the Tuesday after that, my partner, Lori Steiner, is going to be giving a presentation. So you're welcome to register for those as well. But one of the reasons that I like giving these talks is because of the fact that I feel that knowledge really is power. And obviously, I'm not the first person to say this, but the idea is in estate planning, the real goal is to give a person the power to make their own decisions. And a lot of times that is pre-planning for decisions you won't be able to make later because of incompetency, incapacity, or upon your death. So today I'm going to cover the estate planning basics and also talk about what I like to refer to as the core 4 documents. So let's start. One of the things that I've found when I talk about estate planning is a lot of times people say, well, I don't need to worry about that. Only the rich really need to worry about estate planning. And this really isn't true because estate planning encompasses more than just saving death taxes upon your death or setting up a dynasty trust, but rather some of the basics that it addresses is who's going to inherit what property you have, who's going to handle your finances, who's going to take care of you if you're incapacitated, and finally, who makes medical decisions for you in the event you're incapacitated. So estate planning is about a lot more than just saving estate taxes. It really affects all of us. And that's why one of the key words in it is planning. So we want to plan what happens with our estate, not just let it happen to us. So the first thing I really want to talk about is the who inherits your property. So regardless of whether you have a large estate or a small estate, you have the right to plan, to decide who is it that you want to inherit your property when you die. And if we don't decide this, then Ohio and all states have a law of intestate succession. What that means is that Ohio law will say if you have a probate estate, then here are the people who will inherit if you haven't made that decision. So usually it's going to go to your nearest next of kin. And for some people, Maybe that's okay. But the idea is that the estate planning with a will, which is one of the first core documents, gives you the right to decide the who, the how much. Maybe you have 4 children and you don't want them all to inherit equally. Maybe one of them needs more assistance than others. Or maybe you're estranged from someone. What if you don't have any children? Do you want your estate to pass through probate to your nearest next of kin? Maybe not. Maybe you want to take control over where it goes. It's interesting, but last night I had a very long phone call with someone that I've known a long time. And I'm going to change the name and the facts a little to protect the innocent. But I thought about it today as I was preparing, and I thought it shows a really good example of taking control to make sure that we consider using a will to make sure our wishes are followed. So anyway, this woman's aunt passed away, and she wanted her niece to inherit her jewelry. So this jewelry had been in the family for a while, and she and her niece were very close. And so she wanted her to benefit. So what she did was, according to her nurse, she put all her jewelry into her purse and said to the nurse, "This is for my niece when I die. I want her to have it." The only problem is that there's no will. And so it doesn't just automatically pass to the niece. The aunt's nearest next of kin is her daughter, with whom she is estranged. So even though she wanted the jewelry to go to her niece, unfortunately, it's going to go to her daughter. And so the idea here is she could have taken steps to put that wish into writing so that it would be respected upon her death. So it really, thinking about this and fleshing it out a little more, what happened was the aunt also wanted her niece to be able to bury her and have that right of burial, and also to be the one cleaning out her house. But again, unfortunately, this wasn't put into writing. And so we're going to look then instead at the intestate succession provisions of the law. And we're going to have the daughter with whom she's estranged have those rights first. This issue of who inherits isn't the only issue we address in a will, but we also are going to want to address who handles your finances. And if we draft a will and execute a will, the person who's in charge that we appoint is called the executor. And the executor is the one who's appointed by the court to have the authority to handle the estate, the probate estate. So the idea is, I think it's pretty safe to say that most of us would like to control who comes into our home, who's handling our stuff, who's paying our bills, selling our assets, distributing things, paying taxes when we die. If we want to do that during our life, we probably want to do it also upon our death. So our house is a very personal place, and we probably don't want just anyone coming in and doing these things for us. But if you haven't appointed someone as an executor, guess what? Again, the law is going to provide who can serve. And that person is generally going to be called, at least in Ohio, an administrator. So they're going to be the ones who has that right once they're appointed by the court to do all these things. Another issue becomes, though, if I have an administrator as opposed to an executor, then I probably haven't given them all the authorities to handle my estate that I may have in my will. And what this ends up meaning is that the administrator may also have to go to court and ask permission to do certain things in the estate. So taking control of your estate planning allows you to not only decide who's inheriting, but also to decide who's handling these assets. And it also comes down to your personal assets and effects. So talking about control of finances on death really also brings us to what about during life? Because we may feel that that's much more important. And who handles your finances if you're incapacitated, if you're incompetent and unable to handle them? And so, for example, some people say, well, I don't need to worry about that. I have a joint and survivor bank account with my spouse or my child, so they can handle my finances if I'm incapacitated. And the answer is that may work for a while, but unless that's your only asset and you don't file taxes and you don't have to deal with Social Security or pensions or anything like that, then it's probably not enough. When we want to take control over who handles our finances during our lifetime, we call this a durable financial power of attorney. So in this document, I'm going to be thinking about who do I trust to serve in this capacity? Because if I'm incapacitated when they're acting, then I'm not going to be able to see what they're doing or what they're not doing. I also have to decide when I'm setting this up, what powers do I allow them to have? Do I only allow them to pay my bills, to handle my banking, or do I give them the authority to do everything, and including selling my real estate? So it's important to think about the powers that are allowed. And are there going to be successors? If I appoint one child and think, well, if she can't serve, I'll just go ahead and sign a new power of attorney, but I never do, and that child can't serve, then I don't have anyone. And so it's important to consider in a durable financial power of attorney, am I just going to appoint one person? Am I going to appoint a successor person? The power of attorney allows you to take control over who you want handling these finances. And what happens if I don't have a financial power of attorney and I become incapacitated? Well, I know you won't be shocked to hear this, but the law has an answer for that as well. So the idea is that if I don't have a power of attorney and I need this assistance, then under Ohio law, someone can file to become guardian of my estate. And again, we're using that term estate to really mean anything I own, not to say that I have a large estate, but rather what I do have is considered my estate. And when we have a guardianship, what happens is that a person applies to the court. There's a hearing to determine whether that person's appropriate to serve as guardian and whether you need a guardian, whether you're incompetent or not. And then once a guardian is appointed, they are going to serve until you die or become or are competent again. So the idea is, let's say that I have a stroke when I'm 65 and I become incapacitated and I never regain capacity and I die at 80. I might have a guardianship during that entire time that I'm incapacitated. So it brings up not only that I want to take control over who's making those financial decisions by considering the financial power of attorney, but I also, if I have that lengthy amount of time that I'm incompetent, I really do want to make sure that there are successors on my power of attorney. So one of the reasons that people want to avoid going to court for a guardianship isn't just because they want to control who's appointed, but also because it is costly often to do that, and it's time consuming, and there's reporting to the court. So there's two things happening here when I'm trying to decide about control of my finances. The first is making sure my wishes are followed, that the person I want appointed is appointed. And two is also cost savings, making things a little bit easier for the person who's going to be taking that role on. So if I become incapacitated, I'm not only thinking about finances, but also personal medical decisions. So it brings us to our next issue in the basics of thinking about estate planning, and that is who's going to make my medical decisions. So we've talked about, well, I want to control who inherits when I die, and I want to make sure the person I want is making my financial decisions and that I avoid having to go to court. But I also want someone to be able to make medical decisions. And part of estate planning is also thinking about this aspect of my estate. The person, how do I want to live? How do I want to die? What type of health care do I want? So taking control of this issue is going to be considering the next core document, and that is the healthcare power of attorney. In the healthcare power of attorney, I'm appointing an agent to serve for me in the event that I'm incapacitated to make all sorts of medical decisions that I might be able to make. And these decisions can include not only life and death situations, but also things like, where am I going to reside? Am I going to be in a nursing home? Am I going to be at home with caregivers? Am I going to get a flu shot this year? Do I need to go see the dentist or the eye doctor? And so the person appointed, should they choose to serve, is going to have the control and the decision-making authority outside of the court to make all of these medical decisions, up to and including terminating life-sustaining treatment. Again, when I'm thinking of this core document, I want to think about who's appropriate to serve. Do they have time to serve? Will they respect what my wishes are? So in other words, even if the care I would choose is different than the care they would choose, will they respect what I would want, what I consider quality of life? Or are they going to impose their decisions upon me? And then am I going to appoint successors, someone who can act in the event that someone is unable to act that I've already appointed? So obviously, this is a very important document to consider. And to me, even though people often treat it as an aside, I think this might be the most important one. Our care, our health care, and who is helping us in the event we're unable to do it ourselves. And I know the slide gives it away, but If you don't do anything, guess what? The court is going to, if someone applies, appoint and oversee a guardian of the person. Ohio law has provided for this type of issue. And again, the law is going to say, well, who is going to be given priority? What if there's a bevy of people who want to apply to be guardian of the person? Well, we're going to again look at nearest next of kin. And so my situation with the aunt and niece that I was talking about earlier is a good example of this. So if the aunt prior to death had become incapacitated and needed a guardian of the person because she failed to sign a healthcare power of attorney, then the first person in line to apply and be appointed is going to be her daughter. And even though estranged, I often find that people do end up in situations like this, seeking to become appointed. Sometimes it's for good reasons, and other times it can be for bad reasons. And so the idea is that, again, we're talking about a plan, estate planning, that I want to plan who's going to make these medical decisions for me. And usually, if I'm thinking about this core document, I'm also thinking ahead of time about different health situations that occur. And I can discuss these then with the agents that I'm going to appoint so that they're not guessing what I would have wanted in this particular situation, but rather know what my feelings are. So in addition to the document, it's important to breathe some life into it by having those difficult heart-to-heart discussions. And I often speak with someone from hospice, and when she does a presentation, she really goes into how important those conversations are, and that she can tell a big difference when someone just signs a healthcare power of attorney versus someone has had that difficult decision with the person that they've appointed, so that they know what type of care is wanted. So the next thing I do want to talk about is the last core document, and that is the living will declaration. And I called it last but not least the living will because sometimes it's thought of in that way. We think of it as an aside. But this, again, is a very important document for people to consider. And it is very different from the healthcare power of attorney. So if I meet certain medical requirements in my living will under Ohio law, I can indicate that I don't want to have life-sustaining treatment continued up to and including artificial nutrition and hydration if it does not provide comfort care. So this living will, I'm not appointing an agent, a person to act, but rather I'm appointing a person to be notified prior to a physician acting on the living will declaration. So the idea is that I am making a statement of my intent as opposed to allowing others to make this decision for me. You know, when I was first in law school, there was a very important case going on about the discontinuation of life-sustaining treatment for a young woman. Her husband and her parents differed on their view. The husband thought that she would not want to be kept alive as a vegetable, and the parents could not make that decision and thought that she should be kept alive at all costs. How you feel about that isn't what's important here, but rather the fact that if she had executed a living will declaration, whether she chose to have life-sustaining treatment terminated or had decided to say, I don't want it terminated in these conditions, it would have been her decision. This actually was, this case was decided, and it gave birth, so to speak, to the living will declaration. Prior to that, they were executed in this state, but we never really knew if they would be effective. And so the living will is really a statement that you are able to exercise your rights, whether you're incapacitated or not. So it's quite the personal freedom when we stop and think about it. And again, if we don't execute a living will declaration, guess what? Ohio law has provisions for that. So the idea is that all of these documents, all of these 4 core documents really focus on giving us the ability to make decisions for ourselves, even when we can't do so because we're incapacitated or we've passed away. And that's why, to me, these are really the basics that we want to consider in estate planning. And we want to also consider these documents to assist us, because it's your life, it's your death, it's your property. And with these documents, it can be in your control. So I am going to stop there for a moment and see if anyone wants to pop into the chat with any questions. Okay, I have one question that I'm going to answer, and that is, how do we register or see the schedule of upcoming talks? And you can see these on our website. We have a calendar on there, and if you click on the next one you see, it will tell you how to register. So you can do it through our website if you don't see it on Facebook. Okay, so I'm almost done, but I wanted to pop in with a few questions of my own. And that is, if I don't have a will and I don't care where my assets go, I'm okay with intestate succession, does it still matter if I think about executing a last will and testament? And my answer is yes. And I'm going to explain why. When I execute a last will and testament, not only can I appoint who will serve as my executor, but I can decide whether they're going to have to post bond or not. So the idea is that if someone is going to be appointed by the court to serve as executor or administrator, the court may require that that person get what's called a fiduciary bond. And what this basically means is that that person would go to a bonding company that provides fiduciary bonds and ask to be to have a bond issued, which will cost depending on the value of the bond. And so the idea is that if that executor or administrator embezzles the money, steals the money, however you want to put it, mishandles the money, then the bonding company will pay back the estate. So the whole idea with that is to protect the estate from a bad acting fiduciary. But if I completely trust the person I'm appointing and who's going to serve, then I can decide to waive this bond. I can say, I'm not going to have this extra protection because I don't feel I need it, which then ends up saving money to the estate. So even if I say, I don't care if my assets pass by intestate succession or my next of kin apply to be administrator of my estate, I still have issues such as that, as an example, that I may want to control. Okay. So someone says, can you get an Ohio living will online and fill it out, or do you have to contact a lawyer? So the answer is that you should be able to find them online. They are state forms, and fill it out. You are not obligated to see a lawyer. You want to carefully follow any instructions and make sure it's appropriately executed so that it is respected. So here's a question. Most, if not all, of these documents can be found on the internet. They look pretty comprehensive. The opinion on using these versus hiring an attorney. Well, I think that it really depends on the situation. Can someone use a document that they find and will it be okay? Sometimes yes. And so the idea is that when you use an attorney, they can explain to you all of your options. Here we've talked about some basics. We haven't talked about other issues that an attorney can help you to discuss and think about, such as what authorities to put into the financial power of attorney, and also if you have a special needs beneficiary, how you can leave them assets, etc. And so there's other things besides the basics in documents that you can discuss with an attorney. You don't have to, but I do think that it is recommended that you review it with someone who can provide you with that advice. Okay. So someone asks, what happens if it's unclear as to whether nutrition and hydration should be removed? And sometimes these things can be challenged in court if we're worried about the actual medical decisions that are going to be made by the physicians who are determining whether you fit the criteria to have nutrition and hydration withdrawn. So the question is, where do you have to file it once completed? And so you can file certain documents that you create in the state of Ohio, but you don't have to. So for example, the probate court will hold an original will. Sometimes people do that, sometimes they don't. There's pros and cons of that. One of the cons being that if you update it and no one knows that you have and you haven't changed it with the court, this can present an issue. You can file the financial power of attorney with the county recorder's office. That, again, we look at the pros and cons. The pro of that is that it's on record and you can get a certified copy of it. The con is that this is now public record. And so if someone wanted to do a search, they could be able to look at the document. The recorder's office also accepts for filing healthcare powers of attorney and living will declarations. So again, when we put these things on file with the recorder's office, those are typically public documents that can be seen. I think they might keep the healthcare and living will offline. I don't frequently file them. So these are all good questions. Okay, I think there's just one more that I didn't answer, and that is lost it. Okay. Well, the good news is my dog and cat are quiet. The bad news is my mouse seems to be acting up. Okay. And what is the typical cost to have a lawyer do all these forms for you? Again, this, is going to depend on what you do. And I would say that a normal range is going to be, if someone's doing powers of attorney and a will for someone, probably under $1,000. If they're adding a trust or other more complicated documents to it, it may cost more than that. So I think those are all of the questions right now. So these are great questions. And it brings up that, when we're doing estate planning, it's really, to me, a discussion. And the benefit of using an attorney, besides providing legal advice, is for them to be able to provide you with their experience as well. Do you have to have one legally to prepare these documents? No, but I think that it can be helpful in making sure that you consider all of your options and that you have things pass as easily as possible upon your death. So I do appreciate your listening. One of the things that's important, I think, for everyone to remember is that there really isn't one size fits all, in my opinion. For over 25 years, I've been talking to people, and lo and behold, of course, we're not all the same. We all have different wishes, different issues, different family members, different assets. But the idea is that knowing that we can plan and knowing what to consider planning allows you to take that control and actually have a plan instead of letting whatever happens to you. So I really do appreciate your attending. And thank you for your questions. I will stick around for another moment in case anyone wants to pop in another question. And you are more than welcome to attend other seminars. Please feel free to email our firm if you have any other questions that you want to ask. And let's see. Whoop, there is one more question. Okay. Okay. And let's see if I can get down to that last question again. Okay. So again, thank you all very much. And we do have these slides available if you think they're helpful, as well as a guide that my secretary will be sending out that helps you put together a comprehensive list of assets and information on the people you may appoint as healthcare power, executor, etc. So take care, and we look forward to seeing you at other talks. Thank you.